Okay, good morning and welcome to the first panel of BALSA's Race in the Law Symposium. I want to thank the members of BALSA for putting this event together. It is very important, of course, given what we have all just went through given in the presidential election. And our focus today is going to be on this morning how laws impact people of color's access to voting. And I'm going to briefly introduce each speaker as they present. And for more information about them, please turn to the brochure, which has their complete bios. But our first speaker is going to be Ben Battles, who is the Solicitor General for Vermont. And he was appointed to that position by the Attorney General for Vermont, T.J. Donovan, I believe in 2017. Ben is a graduate of University of Vermont and then attended law school at Brooklyn, where he clerked for a federal district court judge and I believe on the Third Circuit Court of Appeals as well. But as Solicitor General, basically Ben oversees much, if not all, of the state's appellate litigation and coordinates with other states when Vermont joins other states in litigation. And he is a mentor for the Appellate Project, which empowers law students of color to succeed in the field of appellate litigation. And with that, we'll start with Ben. So thank you for joining us, Ben.
Thank you, Professor, for the kind introduction. It's a pleasure to be invited here today to speak as part of the Race in the Law Symposium. And thank you to VLS and Elijah Freeman and BALSA for having me today. As Professor Latham mentioned, I'm the Solicitor General at the Vermont Attorney General's Office. And an interesting part of my job is that I review and provide recommendations to the Attorney General on all amicus or friend of the court briefs that other states ask us to join on various issues of national significance that may be pending in the U.S. Supreme Court and other courts around the country. In 2020, particularly in the months leading up to the presidential election, many of these briefs concern the right to vote in the efforts that various state and local officials were making or failing to make to ensure that everyone could exercise the right to vote during the COVID-19 pandemic. Many states, for example, expanded mail-in and absentee voting. Some, like Vermont, mailed ballots to all registered voters in the states. Other states extended the deadline to receive ballots, extended the hours at polling places, or made other accommodations like permitting drive-through voting and installing ballot drop boxes. I know that my excellent co-panelists will be discussing some of these issues and some of the cases from last year in greater depth. What I would like to discuss is one particularly troubling legal theory that gained prominence during the 2020 election cycle, and one that seems to be embraced by at least 4 members of the current United States Supreme Court. And that it's known as the independent state legislature theory. And in a nutshell, the theory is that only state legislatures and not other actors like state elections officials or governors or local officials and state courts can determine the rules by which a state conducts its election. Now, this might not sound that alarming in the abstract, but this theory has big implications for the right to vote and to have your vote counted. And I think this is particularly so for communities of color. And it really has the potential to limit the efforts that other actors make to ensure that everyone has the right to vote and to modify election rules in response to local conditions and crises. And this was illustrated by the COVID-19 pandemic. And one particularly problematic aspect of this is that it has the potential to prevent state courts from enforcing state constitutional guarantees designed to ensure free and equal access to elections. And a lot of state constitutions have provisions like this that explicitly guarantee free and fair elections. And these are important, and they don't have direct analogs in the federal constitution. So this is a tool that state courts often use to ensure that state election rules are honoring the right of its citizens to vote. And before I get into sort of where this theory comes from and how it's been applied, I just wanted to note sort of the most sort of extreme example that we saw of this theory in the past few months. And this was what was latched onto by the state of Texas, led by the Texas Attorney General following the election, when it filed an original lawsuit in the United States Supreme Court to throw out the popular vote totals from the 2020 presidential election in Pennsylvania, Michigan, Wisconsin, and Georgia. And the theory of that case was that a lot of these states had modified their election rules, and they had done so through their secretaries of state and other officials in a way that was, in Texas's view, inconsistent with the laws that the state legislatures in those states passed. So Texas tried to sue in the U.S. Supreme Court to have the results of those elections thrown out, and argued that what should happen next was that the state legislatures in those states would determine how to appoint their slate of electors. And clearly no coincidence that all the legislatures in those states were controlled by Republicans, and that, the end result of what they're going to try to accomplish there was to disenfranchise millions of Black and brown voters in cities like Philadelphia, Detroit, Milwaukee, and Atlanta. Luckily, that effort failed, but it vividly illustrates some of the more problematic aspects of the independent state legislature theory if it's kind of taken to its extremes. So to start with explaining where this theory comes from, and it's from two provisions in the federal Constitution. One in Section 4 of Article 1, which says the time, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And then in Article 2, Section 1, similarly, it says each state shall appoint in such manner as the legislature thereof may direct a number of electors, blah, 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 blah. But the idea, so this is a textualist argument from both of those provisions that says that state legislatures and nobody else, because that's what's in the text of the Constitution. They're the ones who have the authority to determine the manner of holding elections, subject to revision by the United States Congress. But but states have the primary responsibility, so they're the ones setting the rules. And so this kind of textualist reading of these clauses didn't really gain any prominence until 2000 in the Bush v. Gore decision. And as you all know, that 2000 election between George W. Bush and Al Gore came down to a recount in the state of Florida. And litigation ensued, and the Florida Supreme Court interpreted a Florida statute to permit the recount to continue past a statutory deadline. I think it was like November 14th or 26th or something like that. And so that was a state Supreme Court interpreting state law. And normally federal courts are required to defer to a state Supreme Court's interpretation of state law. That's kind of a bedrock principle of federalism. But in Bush v. Gore, the United States Supreme Court rejected the Florida Supreme Court's interpretation of its own law and said that was an unreasonable reading of the election statute, and the recount had to be stopped. And the result of that was to hand the election to George W. Bush. Then Chief Justice Rehnquist explained in his concurring opinion and sort of espoused this independent state legislature theory that deference in this situation was not required because the U.S. Constitution expressly gave authority to state legislatures and not state courts to determine how the state conducts presidential elections. Following that decision, that case was really viewed by many people as not to be a real precedent of the court. I mean, it obviously settled the 2000 election, but there was language in there that suggested it was limited to its facts. And with the exception, I think, of one dissenting opinion by Justice Thomas, the court never cited Bush v. Gore again for 20 years. And then in 2015, in a different case out of Arizona, the court, speaking through Justice Ginsburg, seemed to expressly reject this independent legislature theory. And in that case, involves a redistricting commission in Arizona. And the issue is whether the people of Arizona, through a popular referendum, so not acting through the legislature, but acting through the people, which was authorized under Arizona law, could establish a nonpartisan commission to draw legislative districts to avoid partisan gerrymandering. And it was challenged by the legislature, who made this argument that only they had the authority to determine the manner of elections, including drawing legislative lines. In the Supreme Court, in Justice Ginsburg opinion, interpreted Article 1's the use of the term legislature there in those clauses I described to mean the state's lawmaking power, not just the actual body of the state legislature, and rejected the argument that the elections clauses in Article 1 and Article 2 diminish a state's authority to determine its own lawmaking process. So if the state constitution permits the state to make law through a popular referendum or executive branch regulation or judicial interpretation of state statutes, then that is the state's lawmaking authority, and the federal constitution, the elections clause, was not meant to diminish that. So that seemed to be a square rejection of the kind of Bush v. Gore, Justice Rehnquist theory of independent state legislatures. Chief Justice Roberts in the Arizona case dissented, and in his dissent made the textualist argument that we've just been describing. So that's where things stood. And then fast forward to 2020. It's the court has two new justices, Justices Gorsuch and Kavanaugh, and there's an upcoming presidential election in the mid of a deadly pandemic. And so there's a ton of litigation going on around the country, both from states that have made accommodations to their election laws and states that have failed to do so and have been sued. In Wisconsin, the law there said that absentee ballots must be received by Election Day. A federal district court in Wisconsin ordered the state to extend that deadline to ensure that COVID-related delays in the delivering and processing of mail would not disenfranchise thousands of voters. So that was the posture that it went up to the U.S. Supreme Court and Democratic National Committee versus Wisconsin State Legislature. The court ultimately reversed the district court and allowed Wisconsin to enforce the Election Day deadline. And Celina may go into the facts of that case in greater detail because I know she was involved, but I wanted to note the concurring opinions in that case of Justice Gorsuch and Kavanaugh, who both embraced this independent state legislature theory. Gorsuch said, quote, "State legislators, not federal judges, not state governors, not other state officials, are the ones responsible for setting election rules." And similarly, Justice Kavanaugh, in a footnote, expressly embraced the Justice Rehnquist's opinion in Bush v. Gore and said that the text of the Constitution requires federal courts to ensure that state courts do not rewrite state election laws. So that was really the first time that opinion had been cited since 2000. And perhaps coincidentally, perhaps not, but Justice Kavanaugh, I believe, worked for President Bush on that case at an earlier stage in his career. But and a little Vermont connection to that opinion, Justice Kavanaugh also, in a kind of a throwaway line, indicated that there was no real need to make all these changes to election laws and to ensure the right to vote during COVID. And it cited Vermont as an example of a state that did not change its election laws, which was actually completely inaccurate. And our Secretary of State, Jim Condos, actually sent a letter to the U.S. Supreme Court to highlight the error, and the opinion was amended slightly, and because of that. But anyway, so in that case, you have two justices on the record embracing this theory. A couple days later, there's another case out of Pennsylvania, and this is Republican Party v. Bookvar. And in that case, it also involved a ballot receipt deadline in Pennsylvania. And that had been challenged in state court, and the Pennsylvania State Supreme Court ordered that in order to be faithful to the state constitutional provision that all elections be free and equal in light of all the problems related to COVID, to ensure that everyone had the right to vote and cast their ballot, they ordered the deadline extended. The U.S. Supreme Court ultimately declined to disturb that ruling, but 3 justices, Alito, Thomas, and Gorsuch, issued a statement, again citing Bush v. Gore and latching on to what Justice Kavanaugh had done a few days earlier, and said the provisions of the federal constitution conferring on state legislators, not state courts, the authority to make rules governing federal elections would be meaningless if a state court could override the rules adopted by the legislature simply by claiming that a state constitutional provision gave the courts the authority to make whatever rules it thought appropriate for the conduct of a fair election. So that's a pretty radical statement for a federal court to be making, that a state Supreme Court cannot interpret a state law to be faithful to the state constitution. But that is what they said, and so that's kind of the current state of the game. That case came up to the Supreme Court on a sort of a preliminary posture, but that case is still pending, and so it's possible that the court may grant certiorari in that case and actually have an opportunity to. It's obviously not going to affect the 2020 election, but they're still considering it, and it's possible we may see where the court ends up, and if there is a majority for this independent state legislature theory. Justice Barrett was on the court when that case was decided. She had just taken her seat, but she recused herself, and I think citing a lack of time to read the briefs, and it was, I think, the day after she was seated, or a day or two. So we don't know where she is, but and we do know that Chief Justice Roberts has previously embraced this theory, but he may consider himself bound by the 2015 case that he wouldn't join with the other 4. But in any event, it does seem likely, given Roberts' previous statements and what we know of Barrett's leanings, that this becomes an accepted theory at the U.S. Supreme Court. And I think it is very concerning, and for reasons that we mentioned, it really concentrates power in state legislatures, which in many states are overwhelmingly white and overwhelmingly conservative, and takes power away from local officials who can act more quickly and are more connected to their communities to sort of make accommodations to ensure that everyone has the right to vote. And if it does become the accepted theory, I think it really stresses the importance of engagement at the state legislative level, and the importance of making sure the laws that are passed on a statewide basis are really good, and provide some flexibility to local officials to act in emergency situations. I know that in Vermont, the law that we had passed in advance of the 2020 election actually expressly delegated authority to our Secretary of State. It was a one-time basis. It was just for the 2020 election cycle, but a situation like that may provide more ability for state and local executive branch officials to make accommodations to ensure access to the right to vote. And with that, I will let my excellent co-panelists talk about some of how these laws have played out on the ground across the country in recent months.
Thank you, Ben. And I should have mentioned at the outset that we're going to take questions after everyone presents, and we should have adequate time for that. Again, thank you, Ben. Our next speaker is Celina Stewart, who's an attorney with the Women's League of Voters, where she is the Senior Director of Advocacy and Litigation. She's a graduate of Spelman College in Atlanta and Western Michigan Law School, and has played a key role in some of the major cases that were just litigated over the 2020 presidential election. So, Celina, welcome to Vermont Law School, and thanks for joining us this morning.
Hi, good morning, everyone, oh yeah, it's still morning. I love talking to lawyers in training, and so I'm really thrilled to be with you all today. I'd like to thank Elijah and the Vermont Law School Black Students Law Association, Vermont Law School faculty, staff, and students for this invitation. And I also want to give a nod to one of my very own league leaders, Mary Jo in Kentucky, who I think is on with us today, but who sent me the most innocent of notes last night, reminding me that she is from one of the very places where the community is still trying to heal from the tragic events that happened, not even just a year ago. And so I'm going to ask that they share my slides so I can get into this, or let me know if you need me to. Great. Okay, so as I mentioned, Mary Jo is from Kentucky, and her very brief note to me pushed me to shift my presentation a little bit. And so I'm apologizing in advance to my co-panelists. I'm still doing what I said I was going to do, just with a little extra. And I think it's important to address the very real conversation that we need to have as a country around race and power and the role that plays in our elections. So again, thank you to all of those mentioned. So with that said, my presentation focuses on a look at the role that the League played in the 2020 election cycle and how confronting racial inequity drove our work. It was exhausting, frankly, but throughout I remained tired but inspired. And this tumultuous election, which ultimately led to the League taking on our heaviest litigation caseload in more than 100 years. We had more than 60 cases during that 6-month period, which is a lot for a little old team of 3. But what emerged was a nearly 80% win rate, which we're very proud of, and protecting more than 23 voters. So let's talk about how we did it. Next slide, please. Okay, so the basics. Presidential elections happen every 4 years, and this past election was one of the most controversial and competitive in our history. It was riddled with mis and disinformation, one of the greatest political and racial divides, and you could literally feel the tension in families, friendships, and associate relationships. And so many of you likely know that there are 2 consecutive election cycles, so to speak. There's the primaries, which usually start in February, but unofficially in March on Super Tuesday. And then primary elections are a process by which voters indicate their preference for their party's candidate or candidate in general, and in an upcoming general election or local election. This map shows the progression of the primaries, which are unique because it happens over a 6-month period, February through July. I think there were some in August last year too. And there were even some state races that were postponed to August as well. And that really drove our work. So the red states indicate those states that launched primaries in February. So you can see that's Wyoming and places. And then the purple represents the states that had primaries in March. So you'll notice that is really dominant across the map. You'll notice that it was a ton of states, including Washington and California and Arizona in the West, key states like Texas, Florida, and North Carolina, and states in the Midwest like Minnesota, Michigan, and Illinois. The green represents the primaries in April in places like Nebraska, Kansas, Oregon, and North Dakota. And then the blue represents the primaries in May, but I want to skip a little bit, not to look over the May primaries, but in June, you'll notice that also is pretty prevalent throughout the map. And it became what is known as the second Super Tuesday in many senses, because the number of states across the country that had primaries, and then just a few states in pink, like Louisiana in July. Next slide, please. So I want to talk about the general election. So the primaries is where you pick your candidate. Then we head to that big old election that we just had in November. The light green on this map represents the states that allow early voting. And this is Wyoming, South Dakota, Minnesota, Illinois, Michigan, and Pennsylvania. And then the darker represents the rest of the country really opening up for general elections. And you'll notice that the bulk of the country starts early voting in October. And then we have the red states. The red states are those that do not allow voters to cast their ballots early. I like to call these the naughty states with an exception. Oregon is the exception because they are an all vote by mail state, and the process just tends to be a little bit easier. Oregon was the first state in the country to go to all vote by mail in the late 90s. And so all voters are pretty adept at it at this point. So why am I talking about this? I want to talk about the build up through the general election, but then there's also these other factors that influenced why we did our work the way we did. Next slide, please. So we have talked about the election cycle, the processes and such, but this election cycle, as I mentioned, was different because while we were ramping up for one of the most competitive and controversial elections in our history, we also saw deeply concerning racial inequities occurring across the country, which agitated and also created a really tense situation, deepening the racial divide and carried over into deepening what has been or what was a hyper-partisan environment. When I was thinking about this presentation, I couldn't leave this really important context out of the cases that we brought and why we brought them where we did. So to be clear, I think it's no mystery, and hopefully we all can agree on this, but racism is not new to America. We began to see the racial divide become more overt or more open following the election of the first Black president, Barack Obama. But most Black voters and many young white voters came together unified around this idea of hope. Yet following President Obama's term expiring, the presidential race had a noticeably different and often pitting whites against Blacks and the poor against the wealthy. Fast forward to 2020, and the killing of unarmed Black people with little to no penalties caused what I think is a reverberation of hurt, pain, and anger across the country. And so the Black Lives Matter movement rose more powerfully and with new allies joining the fight. The 2020 BLM was unique in that white and Black people came together to stand against racism. And there was a willingness by some white allies to put their bodies in harm's way to further the movement. And so you'll remember that these protests were not just in the United States. The Black Lives Matter protests were both domestic and internationally driven. This was the first for the movement and a clear indicator that the movement was evolving. And all of this was happening at a critical time during the election, particularly the primaries. So let's take a look at that. Next slide, please. So let's talk about the racial tensions and the timeline of things that are happening. So we have, in March, we had, remember, Super Tuesday, and nearly half the country is having their primaries and identifying their candidate for general election. But just days after that was the death of Breonna Taylor, the unarmed first responder who was killed while sleeping during a night knock warrant. The death of this young woman and the AG being slow to act caused anger across the country, especially across, we got lots of letters and feedback from the leagues, like what is the league doing in response to this? And so we saw protests also begin to form, and leading into April again, where more primaries are happening. Then in May, the death of George Floyd sparked the largest rise, I think, in the Black Lives Matter protest movement. This killing was more egregious in that there was a video of this gentleman being arrested, put on the ground with an officer's knee on his neck for 8 minutes and 46 seconds. I think what sparked the pure rage and reaction that we saw across the globe was the fact that we watched a man who started a video alive and well die right before our eyes. And there was another slow response, even though we saw it, life to death on video. We saw more noticeably early voter turnout during that period. And we saw double-digit and sometimes triple-digit increases in not only voters casting ballots, but those who were requesting ballots. It just soared. Then in September, there was another Black man killed in Portland, which spurred protests in the West, and military personnel was dispatched similarly in DC, causing more tensions to rise. Next slide, please. But it's important to overlay the racial tensions occurring with the primary election cycle, which we just did. Now I want to focus on the two parallel movements that really propelled the league's litigation portfolio. I will get into our cases next, but before I do, I want to show the importance of these two parallel movements happening simultaneously and with one goal, really to disrupt the power structure and push government to be responsive to the people, to a particular type of people too, I think. On the right side, you'll see the protesting of injustice, essentially the Black Lives Matter movement and the resulting counter protests that millions of people around the world participated in. And then on the left, you'll see another type of political protest at the ballot box. Voters were clawing at the opportunity to be heard. And the idea that voting doesn't matter was put on the back burner as people said, well, let's see if that's still true. In response, we saw governmental action taken to the next level. In the protecting injustice context, we saw military presence, an increased military presence, and increased policing at BLM or Black Lives Matter protests. And in the protesting elections context, we saw government officials not responding to the surge of voter interest or racial inequities, and in many states acting to limit or suppress the vote in a multitude of ways. I will talk about the 4 types of cases that the League engaged in to push back on voter suppression and work to open access and participation opportunities for millions of voters. Next slide. So in a 3-month period, these are the cases that we did. So I just put them all on a slide because sometimes it's helpful for me to know just what we were doing and where we were doing. So this is just one visual representation of the number of cases that we were doing between the primary and general election season. But of course, as I mentioned, there were more than 60 cases that we engaged in during that 6-month period and had to be resolved ultimately by November. And so for people who like charts, next slide, please. This slide shows the litigation pie, so to speak, that the League engaged in. You will see that the bulk of the pie is around absentee voting. This is our work to expand access for Black and Brown communities to vote by mail or via absentee ballot without having an excuse. But some have asked why we didn't push for universal vote by mail and just be done with it. Well, we were very careful not to do that, understanding that we didn't want to make the choice for voters on how they casted their ballot. Instead, our goal was to litigate to provide as many options as possible so that voters could choose for themselves. And the other important reason is that voting in person is necessary for some communities and some voters, such as those who are visually impaired, who cannot execute a ballot if you sent it to them in the mail because they can't read it or they don't have enough assistance, adequate assistance. And so we work to expand the vote by mail while also preserving in-person voting across the country. You'll see we also pushed back on strict voter ID, that was in Kentucky, and also issues like postponing the election in Wisconsin and Michigan and Ohio. This pandemic happened right when they were coming up against their primaries. And so there were all of these efforts. You all may have seen the crazy crap show that happened in Ohio where they were trying to move it. They declared a national emergency and then the legislature said, we're still gonna have this election. And so this happened all over the country where government and organizations like us were pushing to say, hey, we need more time. We need voters to have more access. We need to make sure that they can exercise their constitutional right without compromising health and safety. So you'll see we push back in a variety of ways. And so on the next slide, I'll go into the 4 types of litigation that we engaged in this election cycle. Next slide, please. So what did the League do when we saw that Black and Brown communities were being targeted in the streets and also had barriers to the ballot box? Well, we sued everybody, or at least it felt that way. So let's talk about our 4 areas of litigation that the League was a party to, either as a plaintiff or as an intervener. So the first bucket of cases is notice and cure. In some states, if a ballot is flagged for rejection, the ballot is just thrown out. Notice and cure prohibits that and requires that election administrators and officials provide notice to voters so that their ballot can be not only flagged, but provide a method for the voter to correct their ballot so it's ultimately counted. Our next presenter, Sylvia, is going to talk more about the administrative process, so I won't get into those pieces now. But the League's cases really were to file notice and cure litigation in places where Black and Brown communities would be most impacted or had the highest rates of rejection. And so we saw places like New York, who had a 14% rejection rate. And of that 14%, 80 to 85% were people of color. And so it was important for us to file in New York to make sure that understanding that more people were participating via absentee ballot, that when those ballots were flagged for rejection, that people had not only noticed, but had a way to fix it in time for it to be counted. And then the next bucket of cases, absentee ballot limitations. For domestic voters wishing to vote absentee or by mail, there are 16 states that require voters to provide an excuse for why they will not be able to vote on election day. Some of these states do provide early in-person voting, however. The other 34 states and Washington, D.C. do not require an excuse from those who wish to vote absentee or by mail. 5 states conduct elections entirely by mail, including Colorado, Hawaii, Oregon, Utah, and Washington, which means that Voters do not need to request a ballot and instead automatically receive one. The other 29 states in DC offer no excuse absentee voting, which means that any voter can request a mail ballot without providing an excuse. So ultimately, we sued in 27 of the remaining 34 states, which included the 16 states that needed an excuse in order to vote via absentee. But we also worked in the other states to relax the restrictions due to the pandemic to make sure voters had access to absentee ballots. So they could not only request it, but they could receive it and drop it off or make a voting plan that was appropriate for them. So some of those states included Alabama, Connecticut, Kentucky, Mississippi, Missouri, Pennsylvania, Tennessee, Texas, and Wisconsin. Next slide, please. Okay, so the next bucket of cases were witness signature requirements, which is my personal bane. In some states, on top of the barriers brought on by absentee ballots and also the excuse process, states sometimes require folks to get someone to be a witness for their ballot. So why is this problematic? For a variety of reasons, but I think the most problematic reason is because some people live alone, or maybe they don't want to go next door to their neighbor who they don't normally talk to, or hell, you don't even know if they bathe. This pandemic, guys. Some people have stopped bathing for a while. I won't sell anything about myself here. Just kidding. In our cases, the league had to push to eliminate that requirement in states like Alaska, Arkansas, Minnesota, Mississippi, Virginia, and Wisconsin. And Virginia is particularly of note because you had to have a double witness signature. And so we wanted to work with the state election official to waive that, because it made it too difficult for people to get not only the first signature, so you have to live with somebody. And if you don't, that's just another barrier for you. But beyond that, we're in the middle of a pandemic and notaries are closed. So notaries are often the places where people get those signatures or their ballots witnessed. And so with those places closed and so many people living alone and not able to leave their house safely, we had to make sure we push back on cases like that, in situations like that. And then finally, ballot drop box limitations. So I mentioned ballot boxes. Ballot boxes are often used as a secure way for voters to drop their ballots off at a secure location like a county election office or a polling site, and is less burdensome on administrators. It also allows voters to drop their ballot at any time instead of being constrained to the polling location hours. In some states, when election officials noticed that more people were requesting ballots, they worked to limit, secretaries of state, to limit the number of ballot boxes that were available. In Texas and Wisconsin, they tried to limit, and Pennsylvania too, tried to limit it to one box per county, even though it serves hundreds of thousands of people. And so it just wasn't practical to have that. And so we had to push to make sure that there were sufficient number of ballot boxes so that the community could be fully served. And so we just thought that rule was silly and that these administrators were, losing their minds close to election. And so we sued to ensure that there were enough ballot boxes to serve the community and that people had enough access to them as well. All this to say that even as we worked to open access for people, we were confronted with bad actors who worked overtime to suppress the vote. But fortunately, the sheer number of people who were compelled to vote for one reason or another, and by both parties, showed up to make their voice heard. And now that I've gone through all these cases and given an overview, thank you, Ben, for making my life easier by going into more detail, I want to leave you all with a quote. My personal mission is to use my talents, training, and skills to liberate as many Black and Brown communities as possible. So that's my personal mission. It's what I call the Celina factor. But having my personal mission is not enough. Sometimes having a mantra or something that you lean on is something that compels you to move and act is so important. And so I want to share the quote that I use most often to inspire me to keep doing this work, even when I'm exhausted, even when I'm tired, or even when, it just seems like it's an uphill battle. The quote is from Desmond Tutu, which I hope all of you know, but if not, I'm going to tell you, so no worries. He is a human rights activist and a theologian. And the quote reads, "If you are neutral in situations of injustice, you have chosen the side of the oppressor, period. If an elephant has his foot on the tail of a mouse and you say that you are neutral, the mouse will not appreciate your neutrality. So there he has been chiding the elephant and looking out for the mice. And so the most important piece of this quote to me is that very first line, because it tells us what we can and should do when we are tapped into our consciousness. If you are neutral in situations of injustice, you have chosen, whether you want to or not, the side of the oppressor. So I encourage you all in this very important moment in your lives where you are being equipped with tools and skills to change the world, that you use it in alignment with whatever your mission, your personal mission is on this earth. And so I know I've gotten on my little soapbox, so I'm just gonna pass it back over to the professor for the next panelist. And thank you all so much.
Celina, thank you. In fact, that was perfect timing because you nailed it. So thank you so much. And I also should have mentioned earlier that for questions, there's a text bubble on the upper right corner of the page that the viewers are seeing. So please enter your questions there. And if you could direct or point out as well who the question is directed to. So thank you, Celina. Sylvia Albert is our next speaker, and she's had a very lengthy career in public service and primarily focusing on voting-related issues. She is a graduate of a fine institution out in Berkeley, California. That is the University of California, Berkeley. And she is a law graduate of the Georgetown Law Center. So Sylvia, thank you for joining us this morning.
Thank you so much for having me, and thank you, BLSA, and all the professors who've been part of this, and thanks everybody for watching. I want to talk about today why we are where we are. So you've heard from my fellow panelists about the cases that have been brought this year and the ways that we have been fighting for access to the ballot. And the reason that you're hearing about it this year, right, was because there was this global pandemic. And all of a sudden, so many more people were affected by these laws. But the reality is, and something that we should never forget, is that the laws actually are working exactly the way they were designed to work, right? When people say the system is broken, well, that's assuming the system was made with good intentions. When the system isn't made with good intentions, it's not broken, it's working exactly the way it was made to. And so when we look at election laws and election administration policies around the country, we can really see that the root of them is aimed at Black and brown voters, is aimed at Black and brown individuals, and making sure that they don't have a voice. So let's go way back to even the idea of voter registration. So voter registration didn't start in the US until the 1830s in Pennsylvania, where they set up a system where people went door to door to collect information on the residents. But that door-to-door process only happened in Philadelphia, not the rest of Pennsylvania, but only Philadelphia, because that's where Black and brown voters were. And they were likely not at home during the days when these people went door to door because they had to work to support their families, right? So that's, I mean, at the very beginning, voter registration as an idea was really made to, you know, shut down the voices of Black and brown voters. Let's go beyond that. Not surprisingly, felon disenfranchisement. The idea that if you are if you've been convicted of a felony, you should lose the right to vote. Well, that goes back to obviously the exceptionally racist criminal justice system that we have, where basically as soon as Black voters were given a voice, immediately laws were passed to criminalize any sort of behavior that was, you know, that Black citizens did, and then of course immediately saying that those people could not vote. You know, we know that 1 in 13 Black Americans have lost their right to vote due to felony conviction, and this is compared with 1 in 56 non-Black Americans. right? So again, this wasn't accidental. We passed laws targeting Black and brown Americans, and then we passed laws saying that those people cannot vote. Other parts of the voting process, voter ID. Well, because of what I would consider wrongly decided Supreme Court case from 2013, Shelby v. Holder, states are basically kind of going willy-nilly with their voter IDs and enacting tons of voter IDs. And this is even as various courts have found that these provisions are being enacted with, I think that the North Carolina court said surgical precision to target Black and brown voters, right? Again, this is not accidental. We know that 25% of voting age citizens in the U.S., of Black voting age citizens in the U.S. don't have a photo ID. That's compared with only 8% of white voting age citizens. So again, this part of the system was made to disenfranchise Black and brown voters. And that is not new or surprising. And it hasn't, it's pretty standard. Something like voter list maintenance, right? The idea that if you haven't voted, you're going to be removed from the voting rolls. Removing people from rolls in general. Something interesting about that, again, not accidental. The chance of mistake on those cleansing of the rolls is much higher with Black and brown Americans. And that's because non-white people are more likely to have common names. So 16% of Hispanic Americans and 13% of Black Americans have one of 10 common names. And that's only 4.5% of white Americans, right? So when you have a common name, it's much more likely that an error will occur, and more people will be removed from the voting rolls than would tend to qualify under already suppressive, restrictive laws about when you remove people from rolls. So let's talk about, the actual voting process. You have voting location distribution, and voting machine distribution, exceptionally racially tinged immediately, right? There were reasons why we all saw long lines in Georgia everywhere we went. And then when you asked why, the answer was there were only 3 machines inside, right? So this isn't accidental. In general, unequal resource distribution across the states is not unusual in any way, shape, or form. Black and brown communities have less machines. They have less accessible polling locations. They have polling locations that are not on transit lines. And then in general, the idea of, having to vote on this one day does not leave for much flexibility. So when you're talking about a system that does not have early vote or absentee voting, then that in general is more aimed at suppressing the votes of Black and brown individuals. So when we're talking about, even absentee voting, let's talk about absentee voting. It is well known that mail service is not as good in communities of color. Again, we can go to the whole history of, racist America to get there, but that is true. So when systems are put in place for absentee voting that are very restrictive, they are targeting Black and brown communities, right? When you say you have to request an absentee ballot by X date, and you have to turn it in by X date, but that time in between is just not sufficient to get a ballot, to fill it out, to return it, and have it actually be able to be counted, that is targeted at Black and brown voters. And also, with the resources issue, that is not just limited to the idea of having enough voting machines in certain locations or having enough locations to vote. When we're talking again about voter ID, where would you get a voter ID? A motor vehicle agency. What communities are less likely to have a motor vehicle agency that is open, every single day? I grew up in a community that had that, but my understanding is that there are DMVs that are open like once a week for 3 hours because the government infrastructure isn't there, right? So every part of the process of voting, from when you're registering to when you show up in person to vote, if you can show up in person, to when you attempt to vote absentee, every single part of that process is really aimed at ensuring that the voices of Black and brown voters are diminished. So let's go to, okay, you've cast your ballot, now is it going to count? As Celina spoke of, lots of states do not have processes where you can make sure that your ballot counts. And again, these are often states that have very little voter education and voter information campaigns, very little attempts to reach out to the community and actually show them how to go about casting a ballot on this very, confusing template. So when a mistake is made, it is more often to be made by a voter of color or somebody who hasn't interacted with the system before. And if you don't have a process for fixing that, then of course a voter of color is the one whose ballot is less likely to be counted, right? We can go through, all areas of voting law. And what I want to highlight and get everybody to understand is, as I said before, it is not an accident. These rules were made specifically this way to suppress access to the ballot for Black and brown voters. What happened this year is that access was therefore suppressed due to COVID of non-Black and brown voters, right? So now people started talking about, oh, wait, I shouldn't have to have an excuse to vote by mail. But when it was there before, you didn't have a problem with it because it didn't affect you, because it wasn't targeting you. So when we talk about voting reforms, we're not just talking about small fixes here and there. We're really talking about remaking the voting system from the bottom up to make sure that it actually represents the will of the people. And I think you can see very clearly that the politicians don't want that to happen, right? What we saw in Georgia was record turnout. Not only record turnout, but record turnout of Black and brown voters. And so what is the immediate response of legislators in Georgia? Well, we have to revoke no excuse absentee voting. Why? It led to record turnout, but, well, it led to record turnout of Black and brown voters, right? So there will constantly be efforts to undermine the voices of Black and brown voters. And I don't want us to ever forget that that really was the basis for the entire system. So when we talk about reform, we have to go much further than just kind of topical issues, right? We have to go to every single piece of the way elections work in order to ensure that Black and brown Americans really have their voice in Congress, in local state houses, in your school board race, that really we are represented around the country. Thanks.
Thank you, Sylvia. Our last speaker is our only non-lawyer on the panel, Juany Torres, who joins us from Texas. And in reading her bio, she presents to me a classic a story of children of immigrants. She's a first generation American. Her parents immigrated here from Mexico. And it's a story that, to me, belies the lies that have been told by the prior administration about the importance of immigrants to our country. but she attended Stanford University on a Bill and Melinda Gates scholarship. So she must be truly brilliant. And and she's had a lengthy career already in public service. And her most recent effort in this regard was to found an organization called Organize SA. And she's currently pursuing her master's in public administration with the LBJ School at the University of Texas in Austin. And Juany, thank you for joining us this morning.
Thank you so much. I'm excited. Greetings from San Antonio, Texas. So today I'm going to talk more on, yes, I'm the only non-attorney here, though I am getting my master's in public policy, definitely not in the same depth of law or able to practice it the way the other panelists were. But I have found many ways to be able to support and help with voter registration, voter engagement, voter turnout, especially in a state like Texas. So what I'll be focusing on is speaking on how difficult it is in the state of Texas to actually register other people to vote. I'll give you a bit of background as to how this became kind of top of radar for me. So thank you so much again for that introduction. A little bit more. I am a daughter of immigrants. I was born and raised here in San Antonio, Texas. And after I went to my undergrad degree at Stanford University, I worked in tech before joining the Hillary Clinton campaign. Now, with the Hillary Clinton campaign, I was launched over to Nevada, and I worked in Nevada from October 2015 to November 2016, registering folks, turning them out, and learning about how voter mobilization really works in a state that is considered a battleground, that is also one of the most diverse states in the country. And what I learned in Nevada by organizing was that though there are hardships and barriers to vote because it's not automatic, the way that it is perhaps like in Oregon, there was more access and more freedom to actually, as an individual and as a volunteer, register other people to vote. So what did this look like? Well, in Nevada, in Las Vegas, for example, I could go to Latino serving grocery stores like Cardenas, a chain store that is very well known in the Latino community there, and be outside of the store with my clipboard as someone that came from Texas and actually register people, connect with them, talk to them, fill out their forms, give them their receipt, and then they would be ready to vote. When I moved up to Reno, Nevada to go do some work there, or went to Carson City, same thing. I could get out my clipboard and get people registered to vote. No matter where I was in the state, it was a simple act of asking, are you registered to vote? Getting their information, and they were set, right? As long as I turned in those forms, they were going to be good to go. After the Hillary Clinton campaign, I went back home to Texas, came back here, little deflated, right, as the rest of the country was at the end of 2016. And what I realized was that though there was a lot of anger and a lot of frustration, a lot of sadness, there was also this impetus to do something. People wanted to be able and help protect ourselves, our neighbors, our families, our cities against the incoming Trump administration in end of 2016, beginning of 2017. And so I thought, what is the most, as an organizer, you want to be able to create tools and resources and avenues for people that haven't been involved before to get involved. And so I thought, hey, voter registration, it was the first thing I did as a Texas transplant in Nevada. It was very easy for me to do, and I felt really committed to the work. So why don't I try getting people their voter registration forms, and then we can all kind of go across Texas and just register people. And I very quickly learned if I was to do that, I could be prosecuted for a felony. So in Texas, there's 254 counties. If you want to register voters, you have to get certified in each county by the elections department. So in San Antonio, it's Bexar County. You have to go through a training. This training is called the voter deputization training. So you have to be deputized into a role where then you can register voters. This training is not accessible. It is offered on a Tuesday at 10 a.m. once a month. That's it. And you have to drive to the Bexar County Elections Department to go through that 1 hour training And after the 1 hour training, you are then given the certificate to say, okay, you can now register people in your county. It was super burdensome. And so what I realized was like, this is going to be really hard for me to ask working people to make time and go to the elections department, spend an hour of their day, and then still train them on how to organize, how to be able to get folks out registered and then to turn them out. So I decided to create this organization called Organize SA. And through this, I reached out to the Bexar County Elections Department and said, hey, this is something people want to do. They want to help our neighbors get registered to vote. They cannot go once a month to your elections department and actually go through the process. What can you do? How can you help me? And so we were able to find, or I was able to find different venues across the city that were more accessible, and ask the Bexar County Elections Department to come to us, to go into the community so that we can actually deputize people and still go through the Texas law process of going through the program and get their certification, but somewhere closer to home at a more accessible time. So we found an evening on a weekend and then an evening in the weekday to have these trainings. The caveat was that the Bexar County Elections Department let me know that if I did not have minimum of 30 people, I would be blacklisted and never able to bring this up again. So I worked really, really hard, and I had over 100 people at our first Bexar County elections deputization event. So over 100 people were able to get deputized to register voters. And that was the biggest deputization event in Bexar County history. And so with that, that meant that over 100 San Antonians were now certified to go out there and register whoever they wanted. They could take out their clipboard at an HEB. They could take out, their clipboard at a Starbucks. They could be anywhere and register people. Now, in Texas, it is very scary if you are not someone that has done this forever or that doesn't have the privilege of making mistakes in this world to register others, because it is a felony, as I said before, for you to do it without going through the hoops. And so this has led a lot of different national organizations to not want to do work in Texas because of that fear. If I was to, for example, the other important thing I need to say is that certification only lasts you until December 31st of even years. So at most, it lasts you 2 years. And every 2 years, you need to retake the test or retake the programming and get recertified to be able to register voters again. So it is very difficult, lots of barriers to it. But if you were to not go through that program, not get certified as is Texas law, and you wanted to register your mom, that could be a felony. You could be going to jail. It is a criminal violation in the state of Texas to help people register to vote. Now, the other part to this is that as someone currently, as was mentioned, I am a master's student at UT Austin. Austin, full of students, so many opportunities to register people. Because I'm deputized in Bexar County, I could be prosecuted with a criminal violation if I was to try to help students in Travis County, which is where Austin, Texas is, register to vote. So all of this is to share how difficult it is in a state like Texas to actually get people their right to vote and honor it and help facilitate it, especially as folks like us who are all here who care about increasing voting rights and increasing access. So, my takeaways here is just really important to find ways, even if I know all of you here, almost all viewers are going to law school and you will be practicing the law, but finding ways as attorneys and as non-attorneys to support people who want to do right, and then lobby and advocate against these very draconian laws that actually hurt people of color, especially in cities like San Antonio, especially in states like Texas that are minority majority, right? That are more Black and brown than they are other. And so, the reason why I was going last on this panel is because my perspective is one that is much more in practice. What can we do? And I would say it's just so important to take that impetus and learn and do your research and be able to find ways to make things happen for your community. And so with Organize SA, we've been able to deputize hundreds of people to be able to go and register voters. Like I mentioned, every single 2 years, they have to go and get deputized again. But it has helped us, and it's been beautiful to see kind of like the diaspora of folks that are now getting registered, because it's wherever you are, as long as you're certified, you can get out that clipboard and get someone the help they need. So I just also wanted to really quickly share this with the Georgia election, because I know it's come up quite a bit in the other panelists. Stacey Abrams is amazing. She's my hero, and I want to be as amazing as she is in everything she does. But something that I learned, because I was hoping, and obviously with COVID, I didn't get to do it. I was hoping to take a road trip to Georgia and help folks there. I realized that in Georgia, you don't have to be deputized. Like, anybody that was coming in from out of state could actually help do these voter registration drives, which was wonderful, right? When there was so much interest. So I really hope that in states like Texas, especially as people compare Georgia and Texas and like, will Texas go blue? We really need to work on these policies and these regulations and these laws that make it so difficult for people that have the privilege, that have the access, that have the exposure and the knowledge to help those that don't get the basic right to register to vote. So yeah, that's my commentary today, but thank you so much. And I'm happy to answer any questions you have about Texas and where we're headed.
Well, thank you, Juany. I know when we met earlier in the week to discuss the panel, I was shocked when you mentioned that in Texas it was a felony to help people register to vote unless you had gone through this deputization process, which to me makes no sense. And since we're now in the Q&A session, I guess I'll throw out a first question to you, Juany. Is there any effort to repeal this law in Texas, or is that just simply a non-starter?
Yeah, so you can be pursued for a felony. It is a criminal violation. And there's always, good Democrats and good folks that are trying to advocate differently. The Texas Civil Rights Project has been working on this for a long time, but we don't have, unfortunately, the willpower in the state legislature. And they're starting a new session this year. They're actually thinking of removing voter deputy registrars altogether. So it might be that if Republicans are successful in the state ledge this year in Texas, that opportunity I talked about even going to the elections department and getting certified, might not even be an opportunity. It might be that the only way you can get registered is by you yourself going into the elections department or filling out the voter registration form wherever you find it and mailing it. So unfortunately, it looks like we're going the opposite, and it's going to get harder because of the lack of political will from the majority of the state legislature.
Wow, boy. Well, again, thank you for your presentation, and great. Sounds like you did some wonderful work down in Texas as well as Nevada. One question I have for the lawyers is what, I think Sylvia mentioned Shelby County v. Holder, but what impact, if any, did that decision from 2013, which Sylvia says was wrongly decided, 5-4, but what other impact did that have on or if any, on the 2020 election? And I'll just throw that to all the panelists.
Well, so what Shelby County did was basically say, I will try to unlawyer it. Basically, before Shelby County, if a jurisdiction had a history of discrimination in the way that they instituted elections, they would have to go to the Department of Justice before they made any changes. And the Department of Justice would look at it and say, okay, well, this thing that you want to do is going to have a disparate impact on these communities, so no, you can't do it.
So that's the pre-clearance step, is that right?
Pre-clearance, right. That was what was called pre-clearance. You have to get it cleared before you were able to institute the policy. So that went away. And what that has left us with is a system where first of all, discriminatory policies are being adopted left and right. Immediately after Shelby County, I think literally the same week, various states moved to enact things that the Department of Justice had already said they couldn't do. So various states enacted voter ID. shut down polling locations, limited early voting hours, all of these things that the Department of Justice has said, these are, harmful to certain communities, so you cannot do it. They immediately were able to do it. So what has that meant in the last 7 years? Discriminatory policies that have a negative effect on Black and brown voters. So how many people were unable to vote because of voter IDs? How many people were unable to vote because early vote was shut down? There isn't a way to measure the number, but it would be millions.
Thank you. Anyone else want to weigh on the impact of Shelby?
I would just like to add. Yeah, I would just like to add that also, so Sylvia's absolutely right. It was like the very next day, Sylvia, that Alabama started putting in place these crazy laws. But these are our good friends in Alabama. But nonetheless, there's also this dynamic of voter purges, trying to purge potential voters even before an election cycle happens. And that's driven, or the law that governs that is the National Voter Registration Act, which the league was really instrumental in getting passed along with places like Common Cause. But there are people who purge. Normally this is a government activity. So governments are responsible for making sure that the voter rolls are clean. But now what's happened in this last 7 years is that we have third parties, independent people filing requests saying these people should be purged. We saw it in Michigan, we saw it in Pennsylvania, where they're saying, Mark Smith is dead. But what they're not looking into is that Mark R. Smith is dead, but Mark F. Smith is not. And so using slight technicalities like that to get people off the rolls. And in some states, people don't know that they've been purged until election day. And if you don't have automatic voter registration, you're out. You do not get an opportunity to vote. And we saw that happen a lot in Georgia in the 2016 election, where hundreds of thousands of people were threatened to be purged. They consolidated that list and got about 30,000 people who still remained on that list, but still people showed up, had been voting for years, cycle after cycle, and showed up and had no ability to vote. And so there are a lot of things that have happened since Shelby County that makes it easier for suppressors to suppress the vote.
Well, see, I have a question for you. Oh, go ahead, Juany. Oh, go ahead.
Sorry, I just wanted to add in Texas, I was purged last year from the voter rolls, even though I vote every election, because what Texas decided to do, especially after Shelby, because it does make everything easier, bad actors have more rights, I guess, or more ability. They mail a letter out to whatever address you registered. And if you do not respond to the letter confirming, like, yes, I'm here, then they're like, oh, they didn't respond, so they must not live there, so they must no longer be around. Remove. And I didn't know until I went to try to vote in 2020 in the primary, and they're like, ma'am, we can't find you. No, you're nowhere in the system. And I'm like, how is that possible, right? It's been 10 years since I was registered, and I vote every single election. So yes, I just wanted to co-sign and also give an anecdote of how difficult things are.
So you were purged, boy. Yeah, my sister lives in Ohio, which apparently undertook a pretty massive purging effort as part of the 2020 election. But fortunately, she was not, neither she nor her husband were purged. Celina, how did you manage all this litigation with just a handful of lawyers? I mean, I think you said it was you and two other lawyers. And it sounds like you were litigating.
Yes. So we could not have done the work that we do without so much pro bono support. Over this past election. Yeah, we had over 250 attorneys who supported us this election cycle. And in the last election cycle, we had 19 firms. So this was a huge increase. But what was so compelling about it is that there were so many law firms, large law firms around the country who stepped in to support this effort. And so I think that it was really a collaborative effort. The league's name was on the brief, but the folks who were behind the scenes helping us drafting those briefs and making sure that we were positioning ourselves best were so many of the large firms across the country.
Well, and I suspected that was the case. And the reason I wanted to raise that is just to stress to the law students that even if you're not directly, even if your practice doesn't directly impact voting, there are still opportunities for you to play a role. And as Celina mentioned, one role that you could play is as a pro bono counsel to an organization such as Common Cause or the Women's League of Voters when they hit crunch time and are litigating across the country. So even if your specialty is not election law, there's still abundant opportunities to participate and protect the right to vote and access to the ballot. Ben, now this independent state legislature theory, I mean, I have to say, sounds wacky to me. And as I understand it, am I right that it basically would remove state court judges from weighing in on state election issues?
I think carried to its extreme, and that case out of Pennsylvania that I mentioned is that was at least the view of a minority of the justices before Justice Barrett was sitting. So with her, it may be a majority. But in that case, it was a state law that said ballots must be received by X date, and the state Supreme Court, applying the state constitution, said that would deprive Pennsylvania voters of their state constitutional right to a free and equal election, and there was at least a minority of justices on the U.S. Supreme Court said, no, state Supreme Court, you can't do that. It's the state legislature's call. So that's I think that is a really radical view of a state legislature's authority in the federal system to the exclusion of state courts and state constitutions. I mean, the state legislature is a creature of the state constitution, so one would think they would have to operate within that framework. But at least several justices on the U.S. Supreme Court are questioning that.
Man, it seems to me to kick the idea of checks and balances to the curb, basically, and eliminates the role for the judiciary, if I understand this theory correctly. Question for all of you: if you had President Biden's ear, what would you recommend that he do as president to address voting concerns that you've all either litigated or been involved with? And I'll start with Juany.
Oh man. Well, I think one of the best ways that we can actually increase the number of folks that should be allowed to vote from a federal level is by passing immigration reform. I say this as a daughter of immigrants. There's so many things we need to do to help people that are already citizens and born and raised here to be able to have that access that is a right. In addition to that, there's people that have been living in the United States for decades that have contributed to this country, that have paid their taxes and labor, and given so much that deserve and honestly know this country and have loyalty to this country in ways that some folks, especially all those people that stormed the Capitol on January 6th, don't. And I say this as someone that is a daughter of immigrants, someone that has helped her dad go through the naturalization exam when I was in elementary school, helping him quiz through like all these questions to be able to pass it and become a citizen. I think the Biden administration, what can we do? What can he do? Pass immigration reform, give a pathway to citizenship, help people who chose and choose to be in this country and contribute to this country have an opportunity to make this country better. So that is my plea, and I really hope that we can make moves. But there's so many things, and I will let the lawyers talk about the courts and let the lawyers talk about the Justice Department. But I really do think that all of these issues are interconnected. There's intersectionality everywhere. And it's like Texas that have border towns, that have legacies of immigrants. We need to be able to help give them a pathway to contribute to this country in the same way that people like myself can.
Thank you. Ben, what would you tell President Biden about voting and
Yeah, I mean, a few things come to mind, and I think DC statehood is one, and self-determination for people.
Sylvia likes that.
Yeah, and allowing the people of Puerto Rico an opportunity to determine whether they want to become a state, and sort on the more mundane level, the federal government provides a lot of funding to states and localities for election security, and through the Help America Votes Act, and I think the level of that funding could be dramatically increased.
Sylvia.
Well, so to second something Ben said, the funding is so vital. And what people don't realize, there actually is no dedicated federal funding for elections. What you have is the Help America Vote Act that passed during the Bush administration, and that is used as a vehicle every, 10 years for Congress to say, okay, send some money to election officials in the states. But that is not a dedicated fund. It's not normal. They don't know when it's going to come. And what happens is that, as this time around showed, when you're waiting for money and you're not upgrading your systems, all of a sudden you have, you're running off of Windows 2000 and you're supposed to have a 2020 election security plan. Those two things don't coincide, but you haven't been able to update your systems for 20 years because you had no money and no idea when the money was coming. So a dedicated funding stream that it happens every single year, I think is really important. And also would be really important is the passage of HR 1 and HR 4. Obviously, the president is, only one branch of government. The executive is only one branch of government, so he can't do it alone. But what HR 1 would do would set a floor, right? Set a floor that from which we say every American deserves these rights. Right? As a resident of, whether you live in Alabama or you live in Texas or you live in California, you deserve the right to be able to vote absentee if you need to, right? You deserve the right to be able to, vote early if you need to, right? What we have right now is a floor that is so far down, it's ridiculous, right? As Juany was saying, if you're in Texas, pretty soon you're only going to be able to register to vote by going into a voting elections office, which is absolutely insane, right? So the passage of HR 1 would really help basically just create a floor that says every American has this right, and this law will guarantee these rights.
Thank you. Celina, so what would you like to tell President Biden about voting?
Well, we met with his office in January, beginning of January this month. And what we did focus on was, and I think Sylvia teed this up appropriately, is HR 4, which is the Voting Rights Advancement Act. That is hands down one of our priorities. This will be the first redistricting cycle that does not have the protection of the VRA, which means that when we are drawing the lines, the very lines that will lead to how people are represented in this country and their ability to elect a candidate of choice, that will be significantly diluted and diminished if we don't have an effective Voting Rights Act in place. And so I think it is critical for the Biden administration to pass that early, understanding that it's a blessing and a curse that the census data is now happening a little later. States are not going to start to receive that data until July 31st, but that gives us a unique opportunity to make sure that we pass a voting rights bill that restores what was taken out through Shelby v. Holder, and even the attacks now on the remaining section of voting rights, section 2, that's before the Supreme Court in Brnovich v. DNC right now. So that is hands down my priority.
What do you think about making voting day a national holiday? Would that help access? Because oftentimes, particularly for people who are of color, getting time off to vote can be quite difficult. I mean, it's one thing if you're a professional, you can probably take time away from the office to run and vote. But if you're not in that position and your boss wants you to work at a certain time and isn't willing to give you time off to vote, access can be problematic. So thoughts on a national holiday to improve access, or would that not be sufficient?
It's tricky. I'll just say this. I think it's tricky. To pay people. People, even if you make it a national,
that's Celina.
Even if you make it a national holiday, there are people who may not be paid, and there are some people who can't make that sacrifice. Even if it's a national holiday, it needs to be coupled with some type of pay equity that allows people to not only vote, but also not lose money or have options to make sure that they are still economically safe.
So they aren't economically impacted if they decide. Yeah, Sylvia?
And to add to that, kind of what you pointed out is, white collar workers are the workers who get a national holiday off, right?
Right.
That is not going to help the people who really are the most targeted by these types of laws and lack of flexibility. So, the person who works at the corner grocery store, that store is still open on weekends, right? The people who work hourly jobs, mostly still work on national holidays. And then importantly, we need to be careful about using national holidays because of our disabled friends. National holiday usually means that public transportation is severely limited. So when you're talking about disability van access or, all areas of public transportation, that is another burden on lower income individuals and people with disabilities who might not have access to other types of transportation. So it can be a tool in the toolbox, but it's not the answer to all of our problems.
Not the answer in and of itself, because it too presents opens a Pandora box of other issues that
and just by way of reference, in Vermont, town meeting day is a state holiday, and the idea being that people can go to their town's meeting and vote on local issues. But I don't know anybody who gets that off other than state employees.
And law professors at a certain law school in Vermont. but
I was just gonna say
that's about it.
I'm scared of symbolic gestures too. Like, I would love it to be a national holiday, but it's definitely a symbol that I can see many people, like the same people that think racism is over or xenophobia is over now that Trump's out, see it as like, okay, done. Like, now you have no excuse, you Texas Latina, right? Like, no, like there's still going to be so many barriers. And by making this something that people can kind of hold on to, it might diminish the gravitas or power or momentum of other things that need to be done. So I feel like in this country, we're really good about symbolism, but we're not great at actually doing the work, and or at least not lately. So I would be wary of it.
Well, we have about a minute left, so I want to take this as an opportunity to thank you. Thank you all for not only joining us this morning, but also for your work in this very important part of our of your very important work to protect a significant part of our democracy, and that is the right to vote. Each of you are doing tremendous work in this field and should be commended and recognized for it. So I want to personally thank you, and I also want to thank you on behalf of BALSA as well as Vermont Law School for joining us this morning. So thank you, and keep up the great work that you're doing. It's much appreciated and much needed. So thank you, thank each of you. Thank you.
Thank you all.
Thank you so much.